I understand that you're taping this for another room. My wife and I recently went to a Neil Young Los Lobos concert, and they turned around and they said they were playing to the cheap seats. So, and of course all the people in the cheap seats love that. So, people in the cheap seats, hey. I thought it was very cool when Cesar Rojas turned to them with his little mandolin, left-handed mandolin, and played directly to them. I've always wanted to do that. See, they loved it. As Charles Dickens once said, this is in many ways both the best of times and the worst of times. And it's very difficult to talk about either the good or the bad, or the ugly, without referencing the various issues that have occurred, particularly to the Latino community, over the last few years. At a time when there's demonstrably more national and functional racism and restrictionism and nativism, there's also a substantial undercurrent of events that is very life-affirming and spirit-affirming. And I'd like to share with you examples of both of these, because I think that to understand the Latino condition today requires this. But most of you know this. In fact, if you live in Arizona, you know this on a daily basis when you have to defend your looks. But what I want eventually to get to is time for questions. I will leave time for questions. People should have them. At least I will have answers. You might or not have the right question, but I will have some answers. But more to the point, all of us wonder what we can do at this time. And I think that there are several things that all of us individually and collectively can do that I think are extremely important. I will also say that virtually all of these issues that I'll be talking about, in one way or another, lead back to MALDEF. Many roads lead to and from MALDEF, and the difference between the Mendez case, which had no Latino lawyers involved in it at all, and Plyler versus Doe, which had Latino lawyers arguing it and strategizing it, the difference is MALDEF. Our community had ripened to the point where the Latinos, particularly the lawyers in the group, had organized, and we finally had a national organization looking out for our interests. One that, while extremely important, continues to require our support. And I think that there are times when people think that MALDEF is so successful that they don't need our support. And I would just argue that it's never been more essential. And I want to call upon each of you to look into your hearts and into your wallets to support MALDEF. In that respect, I acknowledge our president, Tom Sines, who's here today. Tom. As well as the director of our San Antonio office and one of our crack litigators, David Hinojosa. And his son, the future class of 2016 law graduate, Joaquin, who has been sitting here wheedling his dad to up the stakes about Disneyland, I think. I think David, you just don't stand a chance. The kid's a born lawyer, though, I tell you. We start this story today, building on the back of Mendez and Doss versus Bernal, Delgado versus Bastrop, and other cases, many of them, particularly those in Texas, brought by Latino lawyers. But we start with 1982 and Plyler versus Doe, a case that has had tremendous resilience, one that most of us thought couldn't last, and many people thought shouldn't last because it was such a trajectory. But it has given hope and opportunity to well over 1 million undocumented school children, a number of whom are now our citizen colleagues because of various ways that they move from this liminal status of being undocumented to becoming our brothers and sisters, intermarrying with our families and taking on life as citizens, fulfilling their obligations as citizens. This particular case, of course, is what led to all these DREAM Act students, because without Plyler's permission to allow them to stay in school, we would not have DREAM Act students today. We would not have unauthorized lawyers trying to become lawyers, people who were out of status. It is a substantially changed world, and none of us saw this in 1982. Although, in fact, if you go back and read the early letters, Joaquin Avila, Vilma Martinez, and the early Peter Roos, the early lawyers, I'm not even sure they fully apprehended the significance of the case. It was another it was another case on the docket, and Moldov had been looking for a Supreme Court case. You never know when you take one on if it's going to become a Supreme Court case, and there's an object lesson in that as well that I'll come back to. Then, of course, Tom Sines took up the challenge of Lulac v. Wilson, fighting off the effects of Proposition 187, which ironically struck down all the prohibitions against benefits except post-secondary education. But that was the one piece that was left intact at the time. But then in 1996, federal government passed IRA, and PORA, which, for those of you taking notes, stands for the Act and the Act, both of those, which set out provisions of 1621, the provision that's currently in front of the California Supreme Court in another related matter, saying that states could, in fact, offer tuition benefits and in-state tuition to the undocumented, but they had to do so by enacting a state law. And since that time, 15 states have done so, taken the invitation to do so, although 2 of them have rolled it back. Both Wisconsin and Maryland have frozen or rescinded the provisions that passed law. And so every time we make a step forward, there's always one back, and then we keep moving forward, hoping that the inertia and the arc of our achievements will continue in the right direction. And of course, as of January, there will have been 4 states, my home state of New Mexico, as well as Texas, my adopted state, where I do my missionary work. And where I found my bride, as my father said, I was in a mixed marriage, so I married a Tejana. Let me just say, those of you who know her know that I married way over my head, as all men do. Texas and California beginning in January, and then Oklahoma did allow tuition but rescinded that provision of it, although they still have in-state tuition. And so, at the same time that we have national hate speech, hate radio, hate TV, where we have the American Heritage Dictionary bringing a new word into the world, anchor baby, without any indication that it's a derogatory term, and when we have the style manual of the New York Times insisting upon the words illegal immigrant because they say undocumented is a euphemism. By the way, as if illegal immigrant is not a euphemism. Although there's been some undercutting of that and some people who simply refuse to do it. And I believe that its time, in fact, has come and gone. And at some point it will change, just like the terms Mrs. You don't find Mrs. in the New York Times unless people ask for it. Or illegitimate, no longer in there. And homosexual is very rarely used. In fact, they use the preferred terms of either gay or lesbian. They don't use queer unless it's in the title of a group and so forth. So that these things are all socially constructed and will change, and I think usually change for the better, including self-definition by groups. But that's a completely different story. I will say, at the time that we have these benefits and status being given to states, including unusual states, Utah, which has an extremely restrictionist state statute about employment, in which it insists upon E-Verify. They carved out an exception for undocumented college students, and they allow in-state tuition, and hundreds of students in Utah, of all places, have taken availability of this, as they have in Kansas and in Nebraska, states, in fact, that have been challenged by restrictionists, but at the end of the day, in the 6 cases that have been brought, the good guys have won every one of them. In fact, Chris Kobach has been involved in most of these and has not yet prevailed either in federal or state court on some of these. He and I debated one time. He said, well, I really won Kansas because they said, because they threw out the case on civil procedure grounds, that these students, the people who brought the case, had no standing. And I said, if you're going to claim that as a win, I'll be glad to claim a loss any day. At the end of the day, the statute was left standing, and so that's the kind of argumentation they've had to resort to on this matter, but they've lost in all the states in which they've been involved in this litigation. And currently we have litigation that MALDIF is heroically involved in a case in which David is active. Now, at the same time that we have these good things appearing, we have demonstrably bad things appearing. Arizona, of course, is a dreadful situation, so much so that we really had to deploy MALDIF lawyers away from the Southeast, where there was so much discrimination, into Arizona, because we just couldn't handle all the litigation that was necessary. And Tom Sines has memorably characterized the situation there as 3 Fs and an incomplete. That is, the state, you may have read in the New York Times and elsewhere, along with illegal aliens, anchor babies, and all other kinds of godlessness, that we lost that case. But really, the three of the major provisions were struck down permanently, and one is only available because they couldn't yet prove the harm, and that will come soon enough, even though Sheriff Arpaio is defending himself in court as we speak at the same time. Nonetheless, I suspect it will not take long before we're back in court on that particular issue. And then, of course, Alabama ramped up, and as I have suggested, you can understand why they might do this in Arizona if they're fearful of Mexicans, because after all, Arizona shares a border. But Alabama, well, of course, as you know, they share an ocean with Mexico, and therefore have every reason to fear Mexicans. In fact, the provision they had that was anti-Plyler eliminated all 200 of the Mexican children in the schools that particular month that was in force. All 200 children. This is a very tough crowd, very tough crowd. This is why you want to feed them before I speak, not still bring dessert and sugar. Too much sugar for some of these guys here. So we have a balance of many very good things that you can point to that demonstrably help many, many people. It's estimated that over 20,000 undocumented students have been assisted by the provision, the Texas provision, our AB 540 in effect, 1403. And in fact, it was so successful that Governor Perry, as you know, went down in the debates, went down to defeat in large part. Well, he couldn't count which departments he wanted to eliminate. That was problematic. But he also got beaten up very badly, as you know, for his view on this particular issue of undocumented college tuition. In fact, he accused the others of being heartless for not agreeing with him on that matter. I was asked what I thought about that, and I said, well, even a stopwatch is right once a day. Right once a day. Am I just too nuanced for you, or is it just not? Let me tell you, this kills in front of legal groups. Or watchmakers. They go, God, somebody finally made a watch joke. God, you're our hero. Olivas, you're our hero. I've been given honorary watches every time I make that particular joke. Of course, he took it back the next week when he tried to send the Texas National Guard into Mexico, so that any currency he had gained was taken away after that. But all of these things have occurred in the context of lawyers bringing these important cases because of the depredations aimed largely at the Latino population. Another example, the Garcia case in California, where Cal grants were not being given to citizen children whose parents were undocumented. Think of that for a moment, as if there's an asterisk on being a birthright citizen, that because your parents are out of status, let's say that your father regrettably had a felony, would that make you a felon? Would you be treated differently? Well, in truth, California saw the error of its ways once it was beaten upside the head in court, and they settled. And since that time, Cal grants go to citizens just like they do to other eligible students. And as you know, of course, given what I think is the courageous stand of dreamers and others who brought forward these issues, it was brought forward that they should have tuition as well. And so there will be financial aid using the family as a unit for determination of what the need is, and I think this is a major development. It's certainly been the case in Texas, and it's especially important with the rising tuition that's occurring throughout the various sectors of the California higher education system. However, other states didn't learn, and so New Jersey had to be beaten down, as it was in a case just 6 weeks ago, and Florida, just last week, lost its own version of this, where they were charging out-of-state tuition for citizen children whose parents were out of status. Now, it's one thing when you're younger, when you're Joaquin's age, your domicile is that of your parents. And so if your parents are out of status, you might be removed. In fact, every year we report about more than 10,000 U.S. citizen children because their parents are out of status. And so because we've ratcheted up enforcement, having deported over 400,000 persons last year, having removed that many of their children get caught up in that net, and like dolphins in the ocean, sort of gets, when you're really looking for tuna, you get swept up and repatriated to Mexico or wherever. Now you of course can represent yourself at the age of 18, but you will have lost all the trajectory, you will have in all likelihood lost many of the connections, and you might be just so angry that you don't return to reclaim your country of citizenship. But these are not children, these are people who have reached the age of majority who are not receiving benefits for which they're otherwise eligible, in-state tuition as well as financial aid, simply because their parents are undocumented. And of course this will be struck down when the cases finally play themselves out. But again, the role of lawyers here is extremely important, and I will give a shout out to the ACLU who's brought both these cases, as well as the Southern Poverty Law Center, which brought the Florida case. Now bring us up, therefore, to the DREAM Act, which I know is really sort of ground zero for the DREAM Act, is really here on the UCLA campus as far as I'm concerned, particularly with undergraduates. With the marchas that led to much of the litigation, to the legislation, but also have engaged in the most courageous and selfless form of civil rights protest, where you put yourself in harm's way and bring yourself to the attention of the authorities, so that the larger community will benefit from it. Now, I will say that in my view, and I expect to take some heat from this, and I'm prepared to do so, that time has passed. I think there should be no more self-outing. The DREAM Act is not up for grabs right now. It's been reintroduced, but there's no hearing schedule. I don't anticipate it will be taken up unless President Obama wins again. And I think that the self-outing has lost its efficacy, and in fact, I think what it does now is puts you at risk, makes you ineligible for DACA in all likelihood, and puts your parents at risk. There are 1 billion people on Facebook right now, and half of them are immigration agents. Half of them are immigration agents on Facebook, looking to see the kind of postings that people have that think that they're just for their BFFs.
They're left in the other room.
Are they? Well, yeah. Yeah, this should be the cheap seats in here. Yeah, thank you guys in there in the cheap seats. Now, this brings us to deferred action. And I want to say, before June, there had always been deferred action. In fact, one of the first pieces of legislation on this litigation was brought by John Lennon, the musician in a group many of you probably don't know, which is in and of itself a problem. As I say, it was a group that John Lennon was in with Paul McCartney before Wings. But he had a drug charge and was not allowed to stay in the United States until he sued for what was then called prosecutorial discretion, which meant please put my file at the bottom of the stack. And in fact, he won his case in a very famous documentary called U.S. versus John Lennon. You can see all the details of this. And in that particular case, he and his lawyer sued to have the details of deferred action exposed so that people could use it. And so it became part of the regular activity of immigration reform, particularly for people who are in proceedings. And as I said, both last year and the year before, we deported or removed almost 400,000 persons. It turns out Democrats are really quite good at border enforcement on this. He had also offered deferred action at a lower rate than had the Bush administration, but it was clear that that's a constitutional choice of the prosecutors to pursue certain people and not to pursue others. They can't possibly round them all up, and so they have to make priorities. Well, following the failure of the DREAM Act to be enacted and losing Congress, The administration decided it would try administratively at least to reach out to these children, and so it said we will have very low priority for removal, and we will screen all of these cases, and we will try and have a low priority. And in that, about 300 Dreamers were in fact screened and allowed to remain in the United States. About half of them were given employment authorization at the time. But even that was disappointing. But after a year of that, on the 30th anniversary of MALDEF's victory in Plyler, June 15th, 2012, this last June, the administration announced that it would have DACA, Deferred Action for Childhood Arrivals, which is a really big deal because in the past you hadn't been able to actually apply for deferred action. You simply negotiated it once you were in proceedings, and you could not apply. There was no application form, either for deferred action or for employment. Here now, these students, if they're eligible, can apply for both. In fact, you can't pay for DACA, that's free. The payment that you're doing is for the biometrics, the fingerprints and the other material, but the other money is actually for the employment authorization. They're taking this very seriously, and when that is going to be offered, I just, for example, this week had my first 3 clients go through who they're now at the biometric stage. They have been awarded both DACA as well as employment authorization. This will change their lives. And a group of immigration officials came to Houston to talk with us about planning this. And they said, we'd really like you to get the word out that these kids will get employment authorization. Do you think that they'll apply? And I had to I fell down laughing. That of course, is the whole point of this. Without employment authorization, these kids would have been no better off than before. In fact, worse, because then their files would have been in the hands of the government. Their parents would have been at risk. This is because so many of them live with their parents, and there's no relief here for parents. In fact, there's no relief for them except that their status will be frozen for 2 years, which can be renewed. And even Governor Romney made a virtue of necessity, acknowledging that he would not remove these people before the 2 years was up. He promised, of course, as president, that he would have comprehensive immigration reform in place so that there would be no need to extend it. That was a knowing wink, cheap seats. I think that's the alternative version of self-deportation. I've yet to see anybody who's self-deported, but there you have it. Well, June 15th they announce this, and 60 days later they roll out the plan, and it's a real plan with applications that are online that have frequently asked questions, all of which have really grown from years of litigation about immigration, deportation, and removal. And so today we have bottlenecks, in part because it's been so successful that schools such as LA Unified can't even process the transcripts quickly enough. I will say that one of my students got through, in part couldn't find the transcript quickly enough, so he used the grade report that his mother had signed every 6 weeks for 11 years, while he was in school working his way through. And she'd kept them because Juanito was such a good, my client was such a good student that she kept these because she wanted to show them around home to show what a good boy he was and what a good student he was. In fact, he is a good student. We expect about 1,800 students at the University of Houston, our campus alone, to benefit from this. And we have started moving them through. We're seeing them in groups. And we particularly are urging those who have no criminal records to go through the easy cases. And there will be some people who are probably denied this. If they have serious misdemeanors, if they have drug felonies, if they have DWIs, they won't get it. If they've been away beyond what is called a casual innocent departure. Ronaldo, I'm not sure you've ever had an innocent or casual departure from the United States. All those years of going to Juarez and overseas. But if these kids do the same kind of thing, they may be precluded. But the easy ones ought to be encouraged to move through. Those people who have hits on their records or any questions whatsoever were involved in activity where let's say that they drove without a driver's license. That itself has been said would not be a misdemeanor that would preclude you. But failure to appear might very well be if you didn't take care of it. Or other things. Now, I know a lot of people believe, because word is on Twitter, that you can have things expunged, but they think that sort of automatically means when you turn 18, every juvie record is removed, and that just is not the case. The same court has to go in and expunge it and so forth. So there will be some technical questions. But I will say this, in yesterday's LA Times there was an active question, should these students apply? And I would say it will never get better than now. I cannot imagine a better situation for which these students should apply. The government has asked you to do so, and the line to mistrust the government is behind me. My motto with them is distrust but verify, or these days, distrust but e-verify. Yay! Yay! They finally beat you to a joke, cheapsates. Yeah, it's the sugar kicking in. Yeah, dessert. Yeah, no more coffee for these folks, though. All of that said, I simply cannot, short of comprehensive immigration reform, I simply cannot imagine why you would wait. You're going to wait to see who wins the election? Well, it's going to take time, and some of these could take 6 to 8 months to process. If that program ends on January 21st, and you simply waited too long to apply because you wanted to get your affairs in order, or take your trip to Mexico and then come back and apply, or something like that, or your vacation to Mexico, forget it. It could disappear. This is discretionary, and they can say no. And they've said they will not share these files with any other agency unless there's evidence of criminality. And so if someone has a criminal hit, they should seek legal counsel. But most of these kids can go through without it, and I urge you to do so before you age out. This brings us to the very final point as to aging out. On Wednesday, my colleague Hiroshi Motomura from the UCLA Law School, one of the leaders in this effort, and I had a program on unauthorized lawyers. In part because there have been some cases with UCLA grads and others who now are before the California bar hoping to be admitted as lawyers. Now think of this, who would have thought that there could be such a thing as an undocumented lawyer? I know that there's some MALDIF lawyers who in the past, hadn't paid all their college loans because we weren't paying them enough to do so. So, okay, maybe some of them didn't. Okay, fair enough. But that someone could pass a moral character and fitness test, having been out of status, where, as you know, in all likelihood they have taken a benefit at some point for which they were ineligible. The family may be living with a social security number not their own. There's just a number, or they may have driven a car in unauthorized fashion because you can't get licenses anywhere except in New Mexico and Washington State. My driver's license is from New Mexico because that's where I maintain my domicile and I vote. I carry a passport when I travel because New Mexico doesn't meet TSA requirements. Of course, 30 other states don't either, but just in case, I carry a passport. Well, as a result of the application and the acts of the dreamers, and because of the compelling circumstances, just think of how remarkable it is that someone could get to that point without being able to work, without being able to hold a job, without being able to have been in a licensed profession, without having any federal or state assistance to that point, and having lived in the shadows. The fact that they could go all the way through law school is nothing short of remarkable. And we all ought to be encouraged and cheered and buoyed by their efforts. But the final hurdle is passing the bar and then being admitted in the moral character and fitness, the searching kind of examination that they incur, and being admitted. I'll just tell you one little moral character and fitness joke, because I'm responsible for that at my school, or I was. I once had a student who wanted to explain away his 7 felonies. He had not told us about these. And so I brought him in. I said, why didn't you tell us about these? He said, well, because you wouldn't have admitted me. Well, okay, fair enough. Fair enough. But then he said, well, you're a state school, and these were federal felonies. I didn't think you'd care. Yeah, a continuing fight in the federalism fight. But then my real favorite is the guy who used the existential answer. He said, I'm no longer that person. Well, none of us are. Our lives are like rivers where they're never the same twice, but that didn't explain the one drug offense that was still pending of his 6. So I guess he was appearing, pro se for someone on someone else's behalf, pro hoc vice for someone else. And I said, what were they all for? Because the record wasn't good. He said, well, my friends would stash their drugs under my seat. I was sitting shotgun, and I said, man, you just got to get better friends. That's all there is to that. But if you can get through all the moral character and fitness and the state bars recommend you, that has historically meant you are a lawyer. Here, the state Supreme Court, and in Florida, where exactly the same situation occurs, has meant that they're taking it under advisement to see if it will comport with 1621, which I referred to earlier in case you were taking notes. The same provision that they construed in the Martinez versus UC case that upheld the use of in-state tuition in the state, in which a case that Kovach lost. A unanimous case, and only one member of the state Supreme Court has changed since then. I predict that they will admit him. After all, 1621 says these decisions are left to the states, and if the state wishes to do it, now I will have to live then, or sue someone that says, well, you can't be a member of the bar for being undocumented or something like that. The Supreme Court's actually spoken on this issue with regard to permanent residents and non-immigrants. But it's never had this particular case, but I believe that they're going to take it. And interestingly, every single state bar organization in the state, 18 of them, wrote briefs in favor, including the law deans and immigration professors. The only organized group that wrote against it, regrettably, was the federal government. Department of Justice entered a brief. Now, they must not have talked with the lawyers from Department of Homeland Security, which is offering DACA right now and saying, you ought to give these guys a break. In fact, Florida had said no to this student. They said he's eligible for DACA. He hadn't even applied. He's eligible. We now admit him. We offered to admit him because DACA had changed the ground rules. So, what are the themes throughout this? Well, I believe that all cases, no matter how minor they appear at the front end, are important building blocks for advocacy and legislation that occur after. You just never know. The Mendez case, as you all know, was never taken beyond the Ninth Circuit, in large part because the state simply conceded and did away with the statute that had been so offensive in the first place. And so sometimes you can win, and then you win in the bigger arena. Sometimes we shore up wins and we reevaluate our losses. The case of Rodriguez, the school finance case, is one of those. We've been really looking for the right case since that time, at least I have been, and it's very difficult. Or Hernandez versus New York, a jury selection case that's just so dreadful, one that Dean Moran has written about. We've got to have more Latinos in juries, and if it turns out that if a translator's being used and they're striking Latinos from juries because we know more than the transcript would show, there's just something fundamentally and linguistically wrong about that decision. Sometimes we have to go it alone. The Keys case was brought by black litigants, and it didn't really take into account segregation, racial isolation in the schools in Denver. And Maldiv entered as interveners later, but by then the case had already gone down one path, and we were simply sort of a dollar short on that one. But sometimes our interests will be divergent. At the end of the day, we shake hands and we go on, and so forth. We can't expect all of our wins to be similar to those that other communities will acknowledge as wins. But I would say that coalitions are for the most part good, and we have far more often agreed with these groups than not, but we take it our own way because our clients are Latinos who are, in some instances, very singularly situated. You never know when a case will have matter or significance. Plyler is certainly that case. The early letters on that showed they had no clue just how important that case was going to be. In fact, Joaquin said, well, this may keep our kids who don't live in the district from being able to be in the district, being enrolled in school in that district. Well, yeah, that turned out to be a small matter, and the Supreme Court later took that up in a case called Bynum versus Martinez. But that wasn't really the issue. The issue turned out to be much more significant than that. Hernandez was taken up. It was simply a routine, Hernandez versus Texas, the 1954 Supreme Court case, simply a routine bar fight. Let me tell you these unique facts. One Mexican shoots another in a cantina on a Saturday night. Hasn't happened before, hadn't happened since. I think it happened a dozen times down the street. Maybe not in Westwood. They were throwing sprouts at each other, but you get the idea. Yeah, they were throwing Chardonnay at each other or something. Someone said, well, I don't think this is a very brisk Chardonnay, and they get to a fight. Guy pulls out a gun and shoots the other guy. Well, however this happens, The fact is, in Jackson County, Texas, they'd had 6,000 jurors called, and not one had been Mexican. 6,000 in a county that was 16% Mexican. You figure just the statistical likelihood of every jury having a Mexican was there. And they hadn't found one, hadn't managed to find one. So you just never know. This case simply came in. It was one of 400 that Johnny Herrera had at the time, by my count. Now, each sector has its role to play, and here's really what I want to wrap up and leave some time for questions. The K-12 sector has not historically been as good in reporting the issues to us as we need them to be. I think that given the substantial and growing number of school children we have, that there are a lot more problems out there than are ever reported to us at MALDEF or elsewhere. It's not just MALDEF, of course, it's PROLDEF and other groups doing this litigation, but I think that almost on a school-by-school daily basis, there is something going on that needs to be attended to. And undocumented parents, mind you, are not going to be active in the PTO for the most part, or the PTA, depending on how they call it. And they're fearful. They're grateful that their kids are in school and they don't want to draw attention to themselves. But in the city of Santa Fe, New Mexico, when the city council said we will not cooperate with the immigration authorities, they began rounding up parents. Children are off limits. Plata versus Doe gives them sanctuary in the school. But they were arresting the parents as soon as they dropped off the kids. And no one told us for a while. The governor, a Latina, all of us celebrated Latina wins the governorship in New Mexico, even though she's from El Paso. So, anyway, this is on the order of ABBA being in the Rock and Roll Hall of Fame. It's just one of those things you can't do anything about. You just have to curse because the damage has already been done. But she's trying to undo driver's licenses in the state. And of course, MALDEF right away was there. And her answer was, well, this is, pointing at MALDEF, this is an out-of-state group. Well, first of all, they're not. It's a Texas group. She's Texan, you know. But I wrote an op-ed reporting that we would seek out pendejos wherever they were, no matter what the issue. Unfortunately, pendejada knows no state boundaries. Sort of like us. I don't think that we've brought nearly enough cases in higher education as well. We have brought a few, particularly in missions areas, but I think that there are, and we don't really represent individual faculty but there are lots of issues, particularly at the statewide area, that I think that we need to look further at. And I would urge all of you who are scholars to continue to look very carefully at these areas, such as the Civil Rights Project here has done. In addition, there are many things that lawyers in practice can do. I every year have at least 5 or 6 lawyers who graduated without taking immigration, and they find themselves practicing criminal law or family law. You just can't do that in Texas without taking immigration. So they take my class, and I sign a letter for them to get CLE credit. They don't have to take the exam, but they have to show up and have to be prepared and so forth. And I insist that each one of them do 3 services in return. They take on an asylum case or something like that. I think there are many professionals who could help, but they could all give money to MALDEF. And they could do so including through their employers, many of whom also will match funds. And we will not be able to undertake this work that helps all of us. All of us, even the advantaged ones, even those of us born citizens, if we don't have our organizations with independence and the ability to take on cases that arise as they so do, and often in an oblique, orthogonal, indirect, diagonal kind of way, where you don't realize at first that it's really that bad. And then all of a sudden you go, Florida hasn't been letting citizen children get in-state tuition because their parents are not. How can this stand in a world like ours? How can we let that happen? How can we not have heard that? Well, because we closed up our MALDEF office in Atlanta in order to go to Arizona to litigate where we didn't have an office. Finally, I think that we've had a great deal of energy. All of us heat up a room by cursing the darkness. That's one of our favorite activities. I know that I've done my share of this. But we have to think more strategically. And I think that means, how can I be of help? What can I do? I'm lucky I made it. I stood on someone else's shoulders. I climbed the mountain where someone else left the markers for me. Have I left the trail as clean for the people who will follow? The right wing, believe it or not, is plotting every day. The Alliance Defense Fund and other groups are really the major actors today, not the ethnic organizations. But they stole a march. Their language, their argot comes from us. They all admit that they took their practice, successful practice, from the Legal Defense Fund and from MALDEF. And our success pointed the way for them. And I believe that imitation is a serious form of flattery. They are stealing a march on us. They're the ones bringing important cases, going around looking for clients, raising money, contributing their services, gaining community solidarity and support, writing op-eds, doing the kinds of things that we have historically done, though not as often and not with as much access as they have. So it seems to me that we ought to take a march from them, which is, how do we define these issues? How do we stay engaged with it? How do we call people out? When your newspaper uses illegal alien, or even worse, anchor baby, that scurrilous term, because after all what it means is that a citizen child can bring their parents here. Well, how clever of them to be arranged to be born in the United States so that 21 years later they may apply for their mother, who can then get in line. How clever of them. We need to point these out. We need to be vigilant. We need to raise our voice. Every time that I'm quoted in the newspaper, there will be 10 or 12 newspaper trolls who online write, "Wow, why don't you go back to Mexico? My people came here in 1695. Where am I going to go?" Honest to God. The line crossed us. I mean, we didn't cross the line. And I rarely go anywhere where I'm speaking that's not a friendly congregation such as this, where I don't get a letter saying, "Well, what exactly about illegal is it you don't understand?" In this attempt to further discourse with me. Well, I think we just simply need to get better at it. Each of us needs to examine our own circumstances, our own resources. We need to support our own. We need to support our organizations. We need to back them and back them to the fullest. I call upon all of you to do so. And I remind you that everything I've talked about today started with or ran through MALDEF. Without MALDEF, we would not have Dreamers. And every DREAM Act student ought to know that, as well as all of us in the community who are going to prosper by these kids being our brothers, our sisters, our citizens eventually. They are here. 2/3 of the public school enrollments in the state of Texas are Mexican right now. 2/3. And these are kids already here. These aren't kids coming. These aren't kids who are going to arrive. These are kids who are here. Why do you think the UT Fisher case came about? Because the feeling that Anglos have that we are overwhelming the system. This is our time. And demography has given us opportunities here, and we need to make sure that democracy does so as well. And that's how I end. Thank you all very much. Carlos, how long do we have?
10 minutes.
10 minutes. 10 minutes. Okay, I'd be glad to take any questions. I'd be glad to provide the answers to your question. If you want to dispatch somebody for the cheap seats, you're welcome to do so. You not answered every single question? Oh, God, that's the first time. Yes, in the back. Yes.
To that, because we're complaining. Some people are complaining about affirmative action and race, and yet isn't that some kind of preferential treatment?
Well, they'll be paying full freight out of state, and of course, even so, it's better than the deal they would have gotten in their home state in all likelihood. Well, it seems to me that it didn't preclude bringing Mexicans here or other Latin Americans, number one, as part of the foreign contingent. And I have nothing against that at a certain extent. If the rules are there and they come in honestly and through the front door, and they're not given alumni privilege or the other kinds of things that sort of constitute white privilege, I think that that's fine. And Sylvia Hurtado and other Latinos were involved in coming up with the criteria for UC admissibility, and so I feel that the policy was in pretty good hands. I think we just need to get more of our kids to apply, and I think that the financial aid will help. Of course, not all our kids, as you know, are undocumented. We got a lot of citizen children here. What breaks my heart is that more of those don't apply, or they go to schools where their curriculum choices lead them so that they don't take calculus. You can't take an SAT today without calculus. So just, that we don't have more Jaime Escalantes out there and more brothers and sisters who are bringing along the others and so forth. I understand, frankly, that there are many lures that our smart kids have, including gang opportunities and other kinds of things off the books and work, because they can't put off until tomorrow what they think they can get today. But just the sheer size of the numbers means we're going to have more of these kids here. I think we do need that every school needs to have more faculty and more staff who are supportive of this. And there are opportunities here for us with people who are retiring to try and fill some of these vacancies. So, there's going to be an enormous turnover just in the next 5 to 10 years. I'm not sure that we have, Joaquin, never let a kid get in your way, That's the first rule of movie making. Don't appear with a cute kid. So I think that there are opportunities here for us, and just the sheer demography. I don't think they can ignore us. When Ray and I Ronaldo and I went to school years ago, we were really in the minority. I mean, there were very, very few of us. I remember you could almost count the number. Today, you walk around campus and it's a completely different world, and they're out and they're loud and they're proud and they're involved, and I think that in some respects, it's never been better. That is, if these kids would decide to go to graduate school and see some value in it, or go to the law schools. But today we have just about as many Mexican American law students as we did in 1981, the year I graduated from law school. What's happened is the displacement has occurred largely, or schools have taken the easy way out of getting immigrant children, and by that I don't mean immigrant Mexicans, I mean international students or people from other Latin American countries. And those have taken the place of Mexican Americans, and I have no problem with that. I think that many of them are excellent students and deserve to be here. But where are the Chicanos? We're 70% of the country's Latino population. How can we have fewer? We ought to be swamping these schools, it seems to me. And yet, I know students who won't apply. They don't think they can afford to apply. They don't know that you can get fee waivers, just as an example. Last Tuesday, I met with some students. They didn't know that you could get fee waivers to apply. One of them had taken the LSAT and only applied to one law school. He's entitled to apply to 4 just by virtue of paying for it. He was entitled, he didn't. He applied to one school, a school I'm pretty sure he can't get into, to tell you the truth. There's lots of work to be done, and I think that having more Latino and Latino faculty and staff mean that the applications that do come in are treated with more respect, more consideration, full file review, and the like. But the UT case, should we lose that, is going to be a real serious blow, and not just to that campus. Yes, Ronaldo?
Thanks, Michael, for a lot of information and contextualization. By the way, it's Tijuana, not Juarez. There's a question that has to do with the combination of the employment restrictions for undocumented individuals and higher education, particularly graduate school, that I wondered if you could comment on. And that is graduate students that may not have papers, and part of their work in those graduate studies might involve teaching assistantships. Yeah, right. And whether or not those are defined as apprenticeships, they still have to go through an employment process.
Yes.
To do that.
That has been very problematic, especially in public schools that, for the most part, historically not an attempt to get at immigration, but simply as a payroll system to pay people regularly, use the payroll system. In California, that largely transforms them into employees. They aren't eligible for unemployment and many of the other kinds of employment-related protections, but we treat them essentially as employees. And the case law sort of runs against the student for doing that. DACA should take care of that. Most of these students ought to be under the age of 31, in which case if they get employment authorization, then they'll be treated as if they're a citizen worker. They'll be a U.S. eligible employee who could take any job. That should take care of that, at least for the 2 years. Sometimes you have to work around it. I understand that. I've done that more than once for my students, where I ended up giving them a fellowship instead of employment because I controlled it because I knew that was a problem, and I had some money that allowed me to do that because we didn't have to use E-Verify for it. It is problematic, but I think that every school could probably work around that. There are some that are easier, like anything else. There's some easy cases. Like I think research assistantships that are a function of being enrolled as graduate students or only eligible for graduate students could probably pass the test. Well, if it were papered properly. And a school, the fact that a school uses a payroll system doesn't mean they're required to. They do so out of efficacy and for ease and for record keeping, but it doesn't have to be that way. And so there may be other kinds of things. They can pay tuition, for example, as well as stipends that are not job related. I just think that there are some ways, and schools have found a way to do this, but it's not a perfect world. But they're eligible for DACA. I would be particularly vexed if you'd asked me this question back in June. I would have said you got no options, but if they're under 31, have no criminal record, et cetera, they can get DACA now and they can get employment, real employment. And this will, by the way, I was talking about lawyers, but I'm talking about teachers and psychologists and doctors. And there's a DREAM Act, a DREAM Bar Association right now. It wasn't until two of these students surfaced that the state bar even asked immigration status. They didn't do so until these kids surfaced, and now they do. There are 11 states that still don't ask it. That being the case, it seems to me that they can't ask it. I mean, they can't. I guess they could consider it, but they don't right now because it's just been so incongruous to expect that we'd have undocumented lawyers, and there's such a papered life. But there are undocumented lawyers, and there are undocumented medical doctors operating right now, and they will all be able to take advantage of DACA if they're not too old, if they haven't aged out, if they haven't done anything else to disqualify themselves. So my answer is sign them up for DACA. And your graduate school ought to take the lead on doing that, making it available for them and then entering it into the payroll once they receive it.
Okay,
Yes.
time for one more.
Oh, yes, you get the last question.
Oh, great,
Yes.
wonderful. We continue to be underrepresented in the legal profession, and you said yourself since 1981, it even goes further. But my question for you is, if you had the opportunity to talk to young people, Chicanos, Latinos, and so forth, what words of encouragement, what would you tell them to motivate them to consider law as a possible future?
You could be like me. How great is that? I tell them that they're gonna, Bob Dylan said it all. You got to serve somebody, and you got to work somewhere, and this is a great profession, and you can do a lot of good. And it's not like a lot of our kids don't have, shall we say, a nodding acquaintance with the criminal justice system, and they know there's a place. In fact, that may be their only contact. I didn't know any, when I was growing up, my father was a liquor store clerk. I did not know any lawyers. It turns out some of the kids that I went to school with had lawyers who were their parents, but I didn't know that. So when I went to law school, I was one of those people, I applied to one law school. And I did it because the one person I knew who'd been a classmate had gone to Georgetown. Unfortunately, I got in, and et cetera, et cetera. But I didn't know that you could do more. I mean, I was one of those pendejos who didn't know better. And so today, I try and make the rounds. All of us ought to, whatever profession we're in, we ought to try and get more of our folks into that, if it's a good profession, mind you. If you're a droguero, you're already doing this. So let me just say, let's model ourselves in the drogueros. You try and recruit new people, smart people into your profession, and you help them by making them make sure they don't make the mistakes you did, and juking the system and applying for it and giving them opportunities. And I've got a brother who's a UCLA PhD in history, and he teaches at West LA. And yesterday, he brought one of his students to the lecture. He says he's thinking about law school. Could you talk to him? And that's what you do. We all know someone that you can take them to, and that's what I spent 8 years studying to be a Catholic priest. I spent my high school and college years. It turns out I was much better at afflicting the comfortable than I ever was at comforting the afflicted. So that's why I left. Plus 8 years of cold showers, let me just say. I actually probably could have handled chastity. It was that damn obedience that was the problem. For me, poverty I still have, but there was that. I had any number of people tell me, you really ought to consider being a priest. A priest told me that. Parents, my mother, a convert to Catholicism, told me that. Turned out my father had been in the seminary. I hadn't known that. He encouraged me. They would arrange for me to go spend weekends up there, so I got to meet some of these kids and so forth. And little by little, I sort of got attracted to it. And almost everything I've ever done was because I saw someone else doing it. I didn't make this stuff up. I had no sort of fresh path. I followed others' paths, and we all do that. And so we need to do that. We have to make sure that when we clear the mountain, that we leave the trail clear for others to do, and point out to them. That's the hard part right here. You know, if I were a medical doctor, I would make sure that no one went into organic chemistry without studying real hard for it, because that's what changes them from pre-med to pre-law. And then they become health lawyers. But every profession has its, if it's a good profession, isn't easy, or everybody would be that. And so you tell them the tricks, and you encourage them, and you hold yourself out to help them. And I think that you point out resources that are there. I've had students and others, intern with MALDEF, get MALDEF scholarships. I've had Puerto Rican students that I've sent to PEARLDEF, in successor Latino justice. I talk with a lot of people because people bring them to me. And all of us can do this. Being a sociolinguist, I mean, there's no clear pathway to that. I mean, God, who would have known? Plus, he's been engaged in the unauthorized practice of law for years anyway. You might as well make him a lawyer. Now he's going to Mexico and studying law. This guy's going to be really dangerous, let me just tell you. All of us have ways that we know we can help somewhere else. In fact, if we would all commit to help one other person, we would easily double and triple the number of people who would find that pathway. Our students don't, as a matter of course, know that, in part because our parents didn't do it, and so it's not natural. It's not a natural pathway, and in part because there are impediments, and in part because some of this is just secret insider knowledge, and you don't get to know that without entering the Holy of Holies and finding out, and someone tells you this. And it turns out it's not impossible. It's not at all impossible. In fact, it's quite possible. The question is making it plausible for these students. Thank you all for your questions. I appreciate the time.